Judges of this Honorable High Court, Honorable Justice Bharti Dangre, Justice Valmiki Menezes, Justice Nivedita Mehta, retired judges of this court, district judges, Learned Advocate General Senior Advocate Devidas Pangam, the President Senior Advocate J. Koel Pereira, senior advocates here, my dear colleagues, and all those of you present here. 15 years ago, in the year 2010, I was a Raw Junior, just about 4 years in the practice, and I was witness to a senior judge visiting our beautiful High Court premises we had in Altino. And on the first Monday, admission day, I remember the senior judge making a statement that on Thursday and Friday, I am only going to listen and take up MACT matters and land acquisition matters. His statement followed, the corporate matters, the corporates have a permanent existence, whereas the existence of the families of those who are waiting for that compensation is determined by what they get from our courts. Ladies and gentlemen, I am honored to introduce to you our keynote speaker in keeping with the theme of Justice H.R. Khanna. It is none other than that very same gentleman who adorned the bench, Justice, retired Judge of the Honorable Supreme Court of India, Justice Abhay Oak. Having devilled in the chambers of Shri V.P. Tipnis and having a huge practice with a focus on PILs, he gave up the same and became a judge of the Honorable High Court of Bombay in the year 2003. He assumed the office of the Chief Justice of Karnataka High Court in 2019 and thereafter took oath as Honorable Judge of the Supreme Court of India in 2021. Well, throughout this illustrious journey, he is and will always be known for his humility and how he could relate to the grassroots levels of society. None other and no other better person than to have the first keynote speak for this H.R. Khanna, Justice H.R. Khanna Memorial speech. Can I request you, sir? His Excellency, the Governor of Goa, Shri P.S. Sridharan Pillai, Honorable Justice Mrs. Bharti Dangre, sister and brother judges of the Bombay High Court, Honorable retired judges of the Bombay High Court, Mr. Pereira, Senior Advocate and President of the Goa High Court Bar Association, the Advocate General of the State, Office Bearers of the Association, senior members of the bar who are present here in large numbers, members of the bar, young students and young lawyers. I consider myself to be extremely privileged and lucky to be part of lecture series in the memory of late Hansraj Khanna. Today I am supposed to speak on independence of the judiciary. Since I am going to address you in the context of life and times of Justice H.R. Khanna, naturally the focus will be on the days of emergency. But to begin with, I must clarify that when it comes to independence of judiciary, irrespective of the party in power, irrespective of the fact whether there is emergency or not, there is always a threat to independence of justice, independence of judiciary. And therefore, the members of the judicial fraternity, namely the judges and members of the bar, have to be always alert and ensure that independence of judiciary is not affected in any manner. I remember to have read one article in New York Times. It was article dated 30th April 1976. It was editorial written perhaps 4 days after the judgment in ADM Jabalpur versus Shukla was pronounced. And very interestingly, in that editorial of New York Times, it is said, if India ever finds its way back to the freedom and democracy,
that were proud hallmarks of its first 18 years as an independent nation, someone will surely erect a monument of Justice H.R. Khanna of the Supreme Court. That's what New York Times says. His monument was not erected. His portrait was displayed in Court Hall number 1 of the Supreme Court. And for me, it was not necessary to have a monument of Justice H.R. Khanna, because he will be forever remembered for what he did for upholding the independence of judiciary and independence and also fundamental rights of the citizens. But for his supersession, he would have become Chief Justice of India on 29th of January 1977 and would have occupied the office till 2nd of July 1977. But I must also say here that there are judges and Chief Justices of the Supreme Court who have been already forgotten. But there are a large number of judges of the High Court who never went to the Supreme Court and they are remembered forever. There are judges of the Supreme Court who did not become Chief Justice of India, but they are remembered forever. Giving example of our Bombay High Court only by way of illustration, we had Chief Justice M.C. Chagla, Justice Chittotosh Mukherjee, Justice P.D. Desai, Justice M.L. Pense. These great judges never went to the Supreme Court, but we fondly remember them. I can add many names to that, like Justice Bhima Dalal, Justice Lentin, and so many other names can be added. Same is the case with Supreme Court judges. Everybody knows, we remember H.R. Khanna, we remember Justice Vivian Bose, we remember Justice Krishna Iyer, we remember Justice J.R. Mudalkar, who much before Keshavananda Bharati has written about basic structure of the Constitution. We remember Justice Hegde, Grover and Shellart, who were superseded. Since we are in the context of days of Justice H.R. Khanna, I want to start with Keshavananda Bharati. Keshavananda Bharati, of course, all of you know. The basic concept of basic structure of the Constitution introduced by that judgment by majority. I want to tell this for the benefit of the students and young lawyers, that I personally feel as a student of law that this is one judgment which kept democracy in India intact. And there are fascinating stories about this judgment. Within 3 days of the pronouncement of the judgment, 3 judges, Hegde, Shellart and Grover, they are superseded. And that paved way for Justice A.M. to become Chief Justice. I must tell you one more thing. When the emergency was proclaimed, there was only one survivor of the majority view in Keshavananda Bharati, that was Justice H.R. Khanna. There is something interesting about Keshavananda Bharati. I am not going to repeat what was said in Keshavananda Bharati. I leave it at that by saying that it is one judgment which even today continues to protect the democracy in India. As a consequence of supersession, Justice Ray became Chief Justice of India. In normal course, he would not have become Chief Justice of India because perhaps he would have retired during the tenure of Justice Grover. I believe in November 1975, he suddenly constituted a bench of 13 honorable judges of the Supreme Court for the purposes of reconsidering or reviewing Keshavananda Bharati. And I read that famous argument by Nani Palkhiwala that he told the bench that the case before you does not involve basic structure at all. And advocate generals of various states said that nobody has requested for review. Very vivid account of what exactly happened before that bench is mentioned by Justice H.R. Khanna in his autobiography. It is worth reading. And ultimately, the bench was dissolved. This is very significant to be remembered by students of law. And look at the sacrifice involved. 3 judges had to forgo the post of Chief Justice of India. I remember this year in 25, as a Chancellor of National Law University at Sambhajinagar, I had arranged lectures by eminent speakers on the Constitution of India. Very eminent speakers spoke there. One of the eminent speakers pointed out something which I was not aware. In 50s, one of the senior judges was told by the then Prime Minister Jawaharlal Nehru that by superseding the senior most judge, he will be made the Chief Justice of India. I am told the judge was Justice B.K. Mukherjee. Within split second, his answer to Honorable Prime Minister was that if you do that, I'll step down. These are the stories of sacrifices. These are the stories of principles of Supreme Court judges of those years. And surprisingly, the supersession was defended on behalf of the government in Parliament by S. Mohan Kumar Mangalam. And what he said today may apply, is relevant even today also. I must say this with great deal of responsibility. What Mohan Kumar Mangalam in Parliament said while defending the supersession, he said that as government, it is our duty to take philosophy and outlook of judge before he is appointed as CJI. This was completely against the ethos of our constitution. Parties may come and parties may change, but this kind of philosophy, this kind of thinking remains, whether in small or large form. Before I go to Justice Khanna's supersession, I must say that the then Law Minister H.R. Gokhale defended that supersession on the floor of the Parliament by saying that if Justice Khanna would have been made Chief Justice, he had short tenure of 5 years, 5 months. As against that, Justice Baig, who was made Chief Justice, had tenure of 11 months. Now, this was the thinking of the people in power. Then comes the case of the famous case of ADM Jabalpur versus Shukla. Before I deal with that case, as we are talking about independence of judiciary, I want to tell with great deal of emphasis for young members of the bar and young students of law that even before Justice Khanna's dissent, at least 3 to 4 high courts took a very bold view. For the benefit of young students, I want to tell you something. Emergency was proclaimed on 25th of June 1975. On 27th of June, the President exercised power under Article 359 and declared that remedies under the Constitution for enforcement of fundamental rights under Article 14, 21 and 22 shall stand suspended. Whereas at that time they had forgotten Article 19. So a similar order was passed in relation to Article 19, I believe, on 8th of January 1976. The argument before various high courts, I am going to talk about only Bombay High Court and of course Madhya Pradesh High Court. I believe it was Justice Sen who had taken the view that habeas corpus petition was maintainable, and that led to the famous judgment in the case, famous or infamous judgment in the case of ADM Shukla. In Bombay High Court, there were bold judges. There was one judge who dealt with a case where the government did not permit, the Commissioner of Police did not permit a protest meeting to be held for protesting against the emergency. And notwithstanding suspension of remedy to enforce Article 19(1), the learned judge boldly held that this is completely illegal. There are judgments, the very famous judgment by Justice Tulsapurkar. When I talk about this right to protest, this happened in emergency. I came across a case as Chief Justice of Karnataka High Court in 2020 or 2021 when somebody wanted to protest against CAA, Section 144 of CRPC was invoked. So in those days, the rulers may have relied upon the emergency powers, but the tendency continues, and I had to set aside that order which prohibited agitation against the CAA. There was one more very famous judgment by Bombay High Court, and that judgment is worth reading, where the government advocate stands up and makes an argument that tomorrow, if order of preventive detention under the MISA, Maintenance of Internal Security Act, says that the detainee should not be provided food, even in that case he cannot maintain a petition under Article 226. Consistently, Bombay High Court, at least 4 judges, I think Justice Bhimadaral, Justice Tulsapurkar, Justice C.S. Dharmadhikari, they took the view that there is a rule of law. If an order of preventive detention is mala fide, if it is illegal, it is not within 4 corners of law, petition under Article 226 will be maintainable. There is a famous case, there was a Marathi weekly, very famous Marathi weekly, started by none other than a great socialist leader, Sane Guruji, who was follower of Mahatma Gandhi. About 11 issues of that weekly were forfeited by the government. Justice Tulsapurkar interfered and he said that this is something blatantly illegal, and Article 226 was invoked. There is very interesting thing the students of law must observe. See the combination of bench which dealt with ADM Jabalpur versus Shukla. Of course, Justice A.N. was the Chief Justice, and you will find that except for Justice H.R. Khanna, the other 3 who were part of the majority became Chief Justice of India. But Justice H.R. Khanna never became Chief Justice of India. I don't know whether any significance can be attached to it, but still it is worth considering. And then came that pronouncement of law by Justice H.R. Khanna. And I want to read only few passages from his famous dissent. As Honorable Governor said, that when Justice Khanna wrote this minority view, he was fully conscious of the fact that he is writing that view at the cost of the post of Chief Justice of India. Please remember, I want to appeal to the young students, please remember the sacrifice made by him. Not only him, as I said, there are several judges who may not have reached the pinnacle. But if you look at the history of judiciary, there were attacks on judiciary, those attacks continue even till today, but there were fearless judges who defended the judiciary, and their only object was to ensure that the democracy and constitution must survive in India. Now, very interestingly, what Justice Khanna holds here is that he says that Article 21 is not the sole repository of freedom. And that's a beautiful analysis made by him. Perhaps same analysis was made by Justice Tulsapurkar and Justice C.S. Dharmadhikari sitting in Mumbai. What he says is in paragraph 530, even in the absence of Article 21 of the Constitution, the state has got no power to deprive a person of his life or liberty without authority of law. This is the essential postulate and basic assumption of the rule of law and not of men in all civilized nations. Without such sanctity of life and liberty, the distinction between a lawless society and one governed by laws would cease to have any meaning. The principle that no one shall be deprived of his life or liberty without the authority of law is rooted in consideration that the life and liberty are priceless possessions which cannot be made the plaything of an individual whim and caprice, and that any act which has the effect of tampering with life and liberty must receive sustenance from and sanction of the laws of the land. Article 21 incorporates an essential aspect of that principle and makes it part of fundamental rights guaranteed under Part 3 of the Constitution. It does not, however, follow from the above that if Article 21 has not been drafted and inserted in Part 3, in that event, it would have been permissible for the state to deprive a person of his life or liberty without the authority of law. Then he says, I am unable to subscribe to the view that when right to enforce the right under Article 21 is suspended, the result would be that there would be no remedy against deprivation of a person's life or liberty by the state, even though such deprivation is without authority of law or even in flagrant violation of the provisions of law. The right not to be deprived of one's life or liberty without the authority of law was not the creation of Constitution. Such right existed before the Constitution came into force. The fact that framers of the Constitution made an aspect of such right as part of fundamental right did not have effect of the independent identity of such right and of making of Article 21 to be the sole repository of that right. I am unable to agree that in view of the presidential order in the matter of sanctity of life and liberty, things would be worse off compared to the state of law as it existed before coming into the force of Constitution. So therefore ultimately what he holds is that the liberty existed even before Constitution came into force. It was essential part of rule of law, which is part of our jurisprudence. Now you have to understand this in the context of days of emergency when Justice Khanna wrote this dissenting opinion. I referred to Justice J.R. Mudhalkar, I referred to Justice Vivian Bose, I referred to Justice Krishna Iyer and many famous judges of the Bombay High Court. I want to tell for benefit of young members of the bar that what we learn from these great judges, or at least why I learned from them, I personally learned from them. Of course, it was very difficult for me to fully follow these great judges. But what I learned from these judges is that after a judge takes oath of office under the Constitution, he should never ever think about his future prospects. Wherever a case comes before him, he has to apply the law, he has to apply the constitutional principles and decide the case. He should not be bothered about what the powerful people will feel about that judgment or whether powerful people will get offended. And therefore, it is the duty of judges that they should not think about consequences of their judgments. Their duty is to see that correct judgments are delivered. And I want to tell this for the benefit of young lawyers and young law students who may be aspiring to join judiciary. I say so in every judicial academy. If you are bold and fearless, perhaps you may not get the higher post or you may get it very late. But what you get is a great satisfaction of abiding by your oath. Even the civil judges take oath of office. Then that oath is as important as oath under the Constitution. So what is more important is the satisfaction you get that you have abided by the oath. The post and future prospects are completely irrelevant. We have completed 75 years of existence of the Constitution. Even after 75 years, rigorous efforts are required to protect and maintain the fundamental rights guaranteed under the Constitution. And most important of those fundamental rights are right to liberty under Article 21 and freedom of speech and expression. With Constitution or without Constitution, when it comes to freedom of speech and expression, I request the young members of the bar and young law students to read the address by Lokmanya Bal Gangadhar Tilak to the juries of the Bombay High Court in famous sedition trial. I want to quote only one sentence what he says. He tells the jury that you are called upon to decide whether there is a freedom of press in existence in British India. And one very interesting sentence in the context of sedition, which Lokmanya has said, he says that I know that British government does not like me, but that does not mean that I should be tried for sedition. That's what he says. And he also says that merely because one person says that I have committed offense of sedition, it does not become sedition. So true even today. So today when we think about the independence of judiciary, we have to think about why their judiciary should be independent. Unless we have independent judiciary, the fundamental rights will not survive, the democracy will not survive. And that's the importance of independence of judiciary. It is the judiciary, I am not talking about only the freedom of speech and expression. It is the judiciary who has protected slum dwellers in Mumbai. It is the judiciary which took a view that slum dwellers may be in illegally occupational slums, but they cannot be deprived of water. It is the judiciary which has taken care of poor and downtrodden, and they are under obligation to do so. We are not talking about, as I said, rights under Article 19, rights under Article 21 can be said to be more important. So therefore, when we have completed 75 years of independence, it is our duty, those who belong to the legal fraternity, to ensure that independence of judiciary remains intact. I'll give only one example of how sometimes, even as of today, we can say that independence of judiciary is under challenge. I'll give only one example, because my time is almost over. That one example is, now we have a collegium system. And fortunately, Justice H.R. Khanna's nephew, Chief Justice Sanjeev Khanna, has gone transparent, and every single document regarding how the collegium system functions is on the public domain. At every stage, right from the recommendation made by the Collegium of the High Court, at every stage, the state and the authorities have their say. The Chief Minister can raise an objection, the Honorable Governor can raise an objection. Then there is IB report. Now IB works under the Home Ministry. The IB report, there is a response of the Government of India, which all comes up before the Supreme Court Collegium. And today we have a scenario where after the Supreme Court Collegium approves the recommendation, it is put on the website, it takes 9 months, 10 months, year for government approving the names of the judges. Once Supreme Court Collegium resolution is on the website, please imagine what will be the mindset of that person. He can't get the work, he feels that he is going to become a judge, but he has to wait for 9 months, 10 months, or even a year or more. Does it not affect independence of judiciary? I am giving only one illustration. And therefore today we have a scenario where Chief Justices say that they sometimes find it difficult to persuade bright lawyers to accept judgeship. Of course, I must say that those who accept it are also bright. But that's the practical difficulty which all the Chief Justices face because of this uncertainty. Therefore, we are talking about challenges in emergency. There were huge challenges because of the law which was prevailing. There was order under Section 3, Article 359. And there was censorship. I am told, I am not sure, I tried to find out material. Even the minority view of Justice Khanna was censored, it was not allowed to be published. That's what I read somewhere, but I could not get those orders. So, the time differs. The persons in power are different. But ultimately, it is irrelevant who is in power. There is always a tendency, a natural tendency on the part of those who are in power to tinkle with the independence of judiciary. And therefore, I thank the Goa Bar Association for starting a lecture series in the name of the late Justice Hansaraj Khanna. Because every year when this lecture is held, we'll be able to convey message to the young lawyers, to the members of the legal fraternity, how important is judicial independence, how important independence of judiciary, and how important are the sacrifices made by judges, the great judges of those years. I close by quoting what Justice H.R. Khanna has said in his autobiography. And this, according to me, sums up what his philosophy was, what was his thinking. At one place in his book he says, there arose a feeling of some satisfaction for having not faltered at the crucial time from what I believed was the correct course. The fact that it resulted in foregoing and losing the office of the Chief Justice of India did not hurt very much, for such consequence was expected from the moment I prepared my judgment in the habeas corpus case, and also because many others have paid much greater price for following the voice of their conscience. Undoubtedly, those moments were not without a tinge of sadness, which invariably is there at the time of parting, whether from a career of a life or from a dear one. It also happens that in such moments of crisis, in the moments when the curtain is falling on a major part of one's life, one has the consciousness of having done what one believed to be right thing. One gets sustenance and support from inner and hitherto unknown reserves of strength. See the humbleness of this man. He says that my sacrifice is nothing. The earlier judges have made much more sacrifices. And I think this one passage in his book sums up his philosophy, his thinking, his approach to the life. And I think if we read this passage, I think it will be education for young members of the bar and young students of law. I thank again, firstly, the Honorable Governor for his great act of generosity. I don't think I have seen any governor holding such important constitutional office helping to start lecture series in the name of a fiercely independent judge. So therefore we must pay compliments to him. And again compliments to Senior Advocate Karya and his team. And I hope and trust that this activity will continue. A trust is going to be formed, and I assure the members of the bar that whenever required, my contribution will be always there for any educational activity to start on behalf of the trust. Thank you.
Thank you, Honorable